I will include in pre-hearing ruling how evidence comes in. So if you assert evidence as an attachment or sent an email, um, it's not in. Evidence comes in through a Justice Department system. It's called the Department of Justice Enterprise File Sharing System, JEFS. Now, that may seem like a pain in the neck, but I feel that each of you need to know that no one's been sitting here reviewing your evidence before I get it. It comes a particular way. When it comes and it's offered, I will review it, and I will review it as fast and carefully as I can. But it's got to come in through the JEF system. But I'll explain all that in the pre-hearing ruling. The JEF system requires a link. We will send a link to all the designated participants. Now, you are all here, and it is important to each one of you to get your case across. When I send the JEF's link, or somebody does, I think it would behoove you all to refrain from sharing it with the world, unless you want your evidence to be buried inside a mass of other paperwork. Let's see. All right. The evidence filing date, I'll tell you right now, is going to be January 3rd, 2025. Also, a note on proposed evidence. These are kind of rare proceedings. It's rulemaking, and it's rulemaking where everybody, or a lot of people, have a big stake in this. All right. In reading the papers, and I appreciate all the care that people put into their papers, and I don't mean to disparage anybody, but I did get the sense in reading it that some among us have a sense that they want to back up a truck full of paper and dump it on me. Well, that is not the way that a hearing works. I know that everybody wants to be careful and they want to give me all the things that they've had and all the things that might be important to them and not leave out anything. Someone even kindly offered to send me his book. I don't remember who that was, but here's a spoiler alert. I'm not going to be reading anybody's book. This is an evidentiary hearing, and there are rules for the things to come in. I want the evidence. It's important. And those of you who've been in this, you know I have put no small amount of work into reading your motions and thinking about them. This will be a transparent hearing. You'll get to be heard. But I'm not going to read anyone's book. The agency has been clear, and so are the district courts, that it's not my responsibility to sift through mountains of evidence to pick out what you might think is probative in the proceeding. Everybody has to have a sponsoring witness. Your witness can tell me why the document is important, what it is, why I should read it, and in particular, where in the document I need to look. That's how a hearing works. Just another note about opinions. A little bit of black letter law. Opinions are kind of like heads. Everybody has one. But the only kinds of opinions that can come into a hearing like this are expert opinions. So if you want me to have the benefit of an expert opinion, you've got to notice your witness as to why he's an expert in what particular area. And we're going to be talking to some of the counsel about this shortly. Why the person's an expert, or even where the document that you're proposing comes from. Because although you're going to give me a bunch of documents on January 3rd, that doesn't mean they're in evidence. Every piece of evidence has to have a foundation. I need to know what it is, why it's important. I'll read it, but I need to know where to go. I need to know where to look and why I should depend on that. And that's your chance to say, this is the study, or this is the document that's important. This is why you should be persuaded and why the agency should be persuaded one way or another. I don't have the luxury of reading mountains. As any of you can tell, I probably don't have the lifespan to read mountains of evidence. On a related subject, No legal opinions, please, for better or for worse, probably usually for worse. There's only one legal expert in the courtroom. That's me. By the same token, though, if there is an element of the statute or the regulation that I need to pay attention to, and you've brought an expert that's competent to talk about it, well, I want to know that. I need to know that. That's why everybody's here. If you can tell me something about why or why not marijuana makes or doesn't make a standard, well, I'm all ears. All right. Unless we work something else out today based on consolidation, every designated participant will be afforded 90 minutes to present its one witness. Mr. Zorn, you and I will talk about your list when time's to get up here. And any designated participant on the other side will get to cross that witness for 20 minutes. Consolidated parties can have 120 minutes and 1 to 2 witnesses. I was originally going to say one witness. Then I thought to myself, well, what profit are they really getting out of consolidating? I think there is merit to consolidating to get your point across. And in reading all of your documents very carefully, a lot of you do share some interest, and it might be well worth your while. No one, except perhaps the government, can have more than 2 witnesses. As it happens, government's only noticed 2 witnesses, but the government's the burden party. And just so that everyone understands, there may be time where the government is afforded some latitude because it is the proponent of the rule. We'll get to that later. After your witness is done, you can have one of 2 things. Before you put on a witness, you can have 10 minutes to introduce the witness, to have a small opening statement. At the conclusion of the witness's testimony, you can have one of 2 things. You can either have a 10-minute closing and everything is transcribed to tell me why I should rely on your witness and your evidence, or within 5 business days, you can give me a brief not to exceed 25 pages. So if you feel that now is the time to tell me about your witness right after the witness has testified, let me know. Tell me. If you want the 5 days for the brief, let me know. But you can choose from column A or column B, not both, no matter how strongly you may feel about the subject. There'll be no colloquy between any of you and anybody else who is not me. I paid for the room. You're not to talk to each other. Apart from the closings I just talked about, there's no argument presented during the proceedings. If there's an objection, I may or may not allow argument on the objection. I will rule on the objection, and then we're going to proceed further without any more talk about the objection. Some of the parties here, including the government, are represented by multiple counsel. Each witness will be directed and crossed by one counsel. Another note, most of you are lawyers, and the people who are not lawyers are people that have worked very hard to be successful in life. There is no jury here. There's just me. There's no jury to impress. There's just me. And I've long passed a point in my life where any amount of histrionics or sighing or exhaling or shuffling about is going to impress me. I've got a lot of work to do. As you know, I've read and I've answered every motion. Motion practice is concluded. But if I see any groaning, shouting, exhaling, anything like that, I just don't have the luxury for it. So what's going to happen is you'll be removed. Now, look, you've worked hard to get here. You've worked hard on your cases. You've worked hard on your papers that you filed. To waste your shot just because of something that just will have no effect on me. I've also raised three wonderful daughters. None of it's going to affect me. None of the. You can't guilt me into anything. I've been doing this for years. I'm almost done. All right. That's everything that I wanted to tell you. But as I had discussed before, I'm going to get to talk to each one of you. I'll ask some questions about some questions that I have, and some of the filings leave me with very little in terms of questions. I've worked hard on looking at your availabilities to try and work them out. Um, and we'll take everybody one at a time. Government, you can approach the podium. And if I could have your appearance and everybody else's appearance, I'd be grateful for the government.
Good morning, Your Honor.
Good morning, Mr. Schwartz.
James J. Schwartz, appearing for the Drug Enforcement Administration.
No, you can do all of them. You can do everyone at your council table.
Along with me is S. Taylor Johnston, Jarrett Lonich, and Julie Hamilton.
Good morning, Your Honor.
Good morning, all. Thanks. Oh, no, you don't get to leave. Who's lead counsel?
I am, Your Honor.
Good. Okay, and let me ask you, I'll start with the hard question. What's your position? Are you arguing in support of your agency's rule?
We are the proponent of the rule. Absolutely. Yes, Your Honor.
Great. Now, you've noticed two witnesses. One of them is noticed as as providing a foundation for 43,000 comments, it looks like to me.
Correct.
Okay. Now, not to ruin the surprise, but 43,000 comments aren't coming in. That's a different part of the proceeding. That's the notice and comment part. As I said to everybody before, for the 43,000 comments, each one of them is valuable. Each one of them has to be read. But that's not part of this process because now, as I promised everybody before, nothing's ruled in, nothing's ruled out. But for your planning purposes, 43,000 comments will exceed my lifespan. That's not what's going to happen. But also, it's not evidence. The only evidence that can come in is evidence that's material, relevant, not unduly repetitious. In my opinion, those are things, and they're really important in the process. They're things that the agency must read and consider. And not only that, for those of you who haven't practiced in the APA, they're parts of the process that the agency has to address in its final order. But it just has no place in a ruling. But here's what I'll do. I understand your position. I know that you've got two witnesses noticed. One of them is to lay a foundation for those comments. Because momentarily I thought that I would have each one of the comments have its own foundation, or to give it to me in paper. But here's what I think I'll do. If you choose, so that you can preserve your issue, if you choose to give it to me in an affidavit, the foundation, I'm not telling you to, but if you choose to do that, and you'll have your chance to object at the time. I mean, you've got a position on it and you laid out your position. I'll give you latitude to do that. But just for your planning purposes, I thought I would tell you that I'm very skeptical about it because it doesn't fit into the APA structure. It's unwieldy. It's certainly going to be cumulative. I can't see that it's material and I can't see that it's relevant, but I'm only giving you a heads up. I'm not ruling on it now. So I want you to have your position. I want you to preserve your position. When the time comes, if you had thought about an affidavit, I will take the affidavit. So I'm not telling you to do that, but those are what your options are. Let me give you another easy one. You had mentioned in your pre-hearing statement that you were thinking of requesting subpoenas.
Correct, Your Honor.
If you do that, get them to me before the homework date, and I'll rule on each one. Let me know why they're relevant. I can guess, but let me know who you want. Identify the person or the title, and someplace where it needs to be served. If I issue them, you've been doing this a long time. You know that you guys are responsible for service, however that happens. All right. And let's see. I think that might be. Oh, I've got an issue about your availability. It seemed to me that you're not available until July or something.
Well, February is very open, Your Honor.
Here's what's going to happen. I want to accommodate you. Look, I tried cases long enough to know that I take my witnesses as I get them. I need to move forward with my hearing. I'm sure, I'm not telling you to, but the government is welcome to be here every day. I would recommend that you are. If you've got a witness availability issue, as I said, I'll try and work with you, but I would imagine that there might be some advantage for the proponent to put on their case first. So whatever date I set, and I think everyone can pretty much expect it'll be mid-February. I would urge you to do what you can to have your witnesses here, particularly since I've given you the option of an affidavit for your foundation witness. We're talking about one witness who's a PhD, and a building full of lawyers. So what I would hope is that if I said something in mid-January, that could be accommodated. Tell me, I've been talking. Talk to me, Mr. Schwartz.
It's been a while since we've had a chance to
Well,
chat,
it is.
so I do appreciate
It is,
this.
but I have always appreciated your hard work.
So given what you said about the possibility of affidavits for foundational, and I assume we can do that also for the NPRM itself, really the only date that currently is problematic would be the week of January 13th to 17th, when Ms. Akinfire-Soye is actually already scheduled to be a witness in a trial. So that's those 13th to 17th dates. The rest of the dates related more to the witness that was potentially now going to appear by affidavit. So,
And don't get me wrong, you still can call a witness. I
sure,
just thought it'd be
sure.
easier for you, since I know what the issue is. I want you to have your issue. I want you to preserve your issue. I can definitely accommodate that.
Okay.
It might be that you might not be the first one up.
Sure.
I may take somebody up, but if your availability, it's a district court case, I take it?
I can look it up. I don't know
you
off the top of my head, but I believe
you're
so.
fine.
Yes, Your Honor.
I was thinking of starting the trial, depending on what everyone tells me, that week, the week of the 13th to the 17th. I was thinking of starting on the 14th. I'm not here to torture people. I mean, if it looks like it's not going to work, we'll sort it out. The APA requires that the hearing has to be set with due regard to the convenience of the parties and their witnesses and their representatives, excuse me. So if I can count on you to give me your witness the second week, I can certainly accommodate that. Does that work for you?
Sure. Thank you, Your Honor.
Sure. And I think that's it for me. Do you have anything for me?
Not at this time, Your Honor.
Okay. Thanks, Mr. Schwartz.
Thank you.
As always. All right. Let's see. Next one up on my hit parade is the consolidated parties of the Office of Cannabis Ombudsman, State of Connecticut, and Ellen Brown. And that is you, Mr. Zorn. Welcome.
Good morning, Your Honor.
Good morning. Can I have your appearance?
Matthew Zorn for the Connecticut Office of Cannabis Ombudsman, Ellen Brown. And then I'll note in my submission, although I suspect Your Honor is going to address that, I also have consolidated the doc app as well in the pre-hearing statement.
Oh, did I leave it out? I didn't mean to. I wasn't being clever. The doc app as well.
And Your Honor, if I would have permission to just use the term patient parties, because I think it'll just be easier to use.
Yes, but it would make a mess of my record later.
Okay.
Because people will be telling me, I'm a patient party, aren't I a patient? And look, the judge could be more patient. He's not that patient either. So what I'd ask you to do is, if you could just call it OCO Brown in the doc app. I know who you are, but I want, if let's say, this shouldn't be because you're consolidated, but let's say that you do have some sort of an issue about whose objection you want to lodge it on behalf of. If you could say that and say, like, on behalf of all parties, let me know. I can hear you. I know what you're doing, but the record often isn't so patient. So let's do this. It notices 3 witnesses. Thank you always for your thoughtful papers that you submit, Mr. Zorn, by the way. You've got 3 witnesses up, and you've got your availability. I've got some issues about the witnesses. I'm going to tell them to you. The limit is going to be 2 witnesses. You can have 120 minutes. All right. I'll let you pick, but I'll tell you what occurred to me as I was reading your papers. All right. Let's start with Mr. Goyle. That he's from DocApp, and the way that it's noticed, it seems like it's anecdotal evidence, and I can't find the relevance as to how it relates to moving marijuana from Schedule 1 to Schedule 3. And since I'd already had motion practice about it, I'd be lying if I said I was motivated to find the relevance. I didn't really want to be telling you no again. But it seems to me that it's anecdotal. It's his opinion. It seems like it has to do with his proprietary software. And his proprietary software is going to work at 1 and 3, even as I've read it. And I went back and I read every paper about him, because my inclination is not to say no. But help me out with this. Like, where do you see his relevance to that narrow issue that I've got? And remember, everybody, this is not a trial about whether marijuana is good or marijuana is bad, because I don't know whether it's good or it's bad. My issues are much more narrow than that. Has to do with addiction potential and several other little pigeonholes that I have. So to the extent that I've ever had an opinion, which it hasn't really entered much into my life, it doesn't matter. But tell me, where do you see his relevance? What's your best argument for his relevance, Mr. Zorn?
Thank you, Your Honor. And let me take a step back. I will answer your question directly, but I think it's my view of the case is this is actually a fairly simple hearing. I've read all the submissions, and I think a lot of people are addressing collateral issues.
Get to it.
A lot of people are addressing collateral issues. It's very simple. Is there an accepted medical use? And if so, is the potential for abuse equal to fentanyl, or is it less than fentanyl? That's my position in the case, is that this isn't like an opiate. This belongs in a schedule lower than that. And the reason I start there is because that ties into the relevance of this witness, actually both prongs, which is Mr. Garrelay he has a software program that he uses in the state of Florida, which collects data from patients. And one of the observations he's going to make is that patients use the software, and they match strains of marijuana to come off of opiates, and sometimes even drop out of the medical marijuana program entirely because they use that to wean off of opiates. And I think that is powerful probative evidence towards at least the second point, that this is not on par with fentanyl, heroin, all of these opiates that everyone in the country is addicted to. So he can attest to that using his software and using data. And I understand Your Honor's point about anecdotal evidence, but his software and the data that he's collecting, I believe, would be very instructive for Your Honor to see that there are efforts, and it's not just him, but there are efforts of entrepreneurs out there to put this together, and have in fact put this together, and that medical programs use this type of data. As far as accepted medical use, I understand that there's a dispute amongst all the parties as to what that means. I understand there's a dispute even within the government as to what that means. But my position, and what Mr. Garrelay will also show, is that people are in fact using this medically, and we have data to show that.
Let me jump in here.
Yes.
First off, the only thing that enters into what we decide here, just to prepare everybody, is what I've got in the record. And what I've got in the record is Mr. Schwartz, who I have a lot of confidence in, has told me that he is the proponent of the rule. That they want the rule, they've asked for the rule, and for me, that's what I have, and I rely on him. Now let's get back to Mr. Garrelay. I can't see that he would be any way that there's to put him in as an expert witness on any of it. Look, his software might be great, but as I explained at some length, because of the thoughtfulness, I think, of your brief, he's not an expert on what's addictive. He might have some statistics, but it seems like that's a place, then, from at least the way it's noticed, that's better suited for the notice and comment section. I think, and it would be hard to argue with the fact that his software isn't ingenious in a lot of ways if it does the things that he says. But the rest of it's going to be his opinion. And I can't admit him as an expert, and I can't consider his opinion. And what he thinks about his software isn't going to move the needle. And if it's not going to move the needle, then I'd have to ask myself, where am I going to put it into a decision? Because look, I've heard you. I'm just going to tell you that just because I don't knock anybody out here, if somebody's not given me relevant evidence, what's going to happen is you might have wasted your shot on a witness who I'm not going to take any of his testimony. So a lot of that's going to be a tactical decision on your part, but I'm not seeing it. It's a fairly narrow issue. And his software, even if you believe it, he's a big proponent of letting patients decide what marijuana they have. That's a place for Congress. That's a place for the states. The structure is that the doctor writes a prescription, and there are requirements and the regulations for the prescription. His software seems to conveniently cut out the physician out of the process. So I can't imagine what he would tell me that it's not even whether I agree with it or disagree with it. I can't use it. So I'm telling you what my concern is so you can factor that into your decisions. I guess my concern with your witness, Mr. Preston, it seems like the opinion of a non-expert, and I don't know where it fits in. And same thing with Accenture, the pharmacist. The pharmacist clearly has an expertise that's relevant here on several levels, but he's not noticed as an expert, and I don't know where his expertise would come in the way it's noticed in terms of addiction. Look, I know that pharmacists have a high level of expertise and a high level of education. I regulate pharmacists. But I guess my concern for you is that he has a lot of opinions about things that would seem, from what I've read, to be leaning a little bit too far over the skis. And as far as the patient testimonial witnesses, yeah, we're not going to be doing those. Everybody had a chance to comment. That's part one of the APA. They did their notice and comments. So there's none of them coming in. You had a couple of motions, I guess, at the end of your paper. One of them is that you would ask that the hearing be conducted on the record. Okay. Now,
Sorry,
I'm
Your
going to
Honor,
try not to be offended by that, but just so that everyone knows, everything in this hearing is going to be conducted on the record. Because if you think about what the corollary is, it's, Judge, please don't have a secret meeting with some of the witnesses. You see how that's a little uncomfortable? There will be no secret meetings. Everything will be on the record. If there's an off-the-record conference dealing with logistics, it'll be on the record as soon as we open up again.
Your Honor, and just so Your Honor has some context, I was involved in another formal rulemaking along these lines a couple of years ago, and all the hearings weren't on the record, and there was one very important hearing that wasn't on the record.
The reported case?
It has to do with the 5 tryptamines in Judge Walbaum, and there was something very concerning that was said off the record. So I just want you to understand what.
Let me put your concerns at ease. I have been doing this too long to be escorted out of the building. Everything will be on the record. Also, you had made a discovery request. I've got no authority for discovery. You have other tools at your disposal. You had said that you were asking for a certain discovery at the end of your paper.
I'm not sure. I think I have concerns about the government being the proponent of the rule. Even just hearing today, where Your Honor asked if they supported the rule, and their response was they're the proponent of the rule. Proponent just means that they're proposing the rule. Does not mean that they're supporting the rule. And I thought that question and answer was a little bit concerning for me. And I share the concerns of some of the designated parties here. I still don't know if the government is supporting the rule. And I think that their submission where they disclosed no exhibit, every party here managed to put together all their exhibits. The government is apparently still compiling the exhibits. They have more attorneys here than any other party. And I just think that they're sandbagging us. And I hate to put that on the record, but.
If you hate to put something on the record, Mr. Zorn, then don't. The government is the proponent of the rule. The government also is representing the Drug Enforcement Administration. Now, there's going to be a recommended decision. The head of the agency, whoever that is at the time, is going to be reading carefully all the things that are put in front of that person, and then going to make a decision based on several concerns. One of them is public safety. So it bothers me not at all that the head of the agency that's making such an important decision wants to read it all first. Otherwise, we are all wasting our time. Now, the government has said as the proponent, how they put in their case is up to them, and there's certainly enough people in favor of it that are going to be here and put on a case too. But I've read that in a lot of your papers. Not your, I mean, a lot of yours, the sort of the big we. But I haven't seen a single witness from the government. I haven't seen anything from them. Let's say the government decides in the middle of it that they don't like this as a rule based on public safety, and they do that based on what we do here. That doesn't bother me a bit. That's part of the APA. Half the people in the room are not entitled to have the administrator be a cheerleader. Okay, what they're entitled to expect and what the American public can expect is that I do my very best to get to make a decision that's consistent with the evidence, whether people like it or they don't. But as far as this business with who's a proponent and who's not a proponent, I, you're at the podium, so I'm sorry to give it all to you, but I don't want to hear it.
Yeah.
It's not part of what I have to do, and I've got a lot to cover.
Your Honor, I understand your concerns. My concern, I want everyone to put on their cases. My concern, namely here, and I think you referred to the discovery quest, is it's about notice. It's about fair notice. It's what case are you even putting on? And I know everyone's case from the podium on back. I don't even know their case because they did not put exhibits in their pretrial hearing as Your Honor instructed, and they just said that they're still compiling them. And they clearly have, the government clearly has some exhibits it's contemplating, because when you read above the footnote of where they say we're going to disclose this in the future as Your Honor provides, they talk about those exhibits in the proposed testimony. So they clearly have them in a file somewhere. They just didn't put it in their filing. So the only proposed discovery, I'm not interested in disqualifying parties. I'm not interested in anything. I simply want to know the government's position as far as what exhibits does it intend to present as of today. It clearly has some of them in mind. It didn't put it in its pre-hearing statement. Everyone else put their exhibits in their pre-hearing statement. That's my concern. And so I use that particular word. But again, Your Honor, I just find it disappointing. I can't fathom why everyone else here managed to put a list of exhibits and the government said, we're still compiling our exhibits.
Let me put this to rest.
Yeah.
This might be somewhat helpful. Government, get your exhibit list in by the homework date. All right.
Yes, Your Honor.
I think that's certainly valid, Mr. Zorn. But I can only deal with what I have here. I'll judge their case as it comes in. I'll make a recommended decision, and then we'll move on beyond that. But you said you weren't trying to disqualify anybody. The person who made that motion, that was a very thoughtful motion. I spent a lot of time with that to look at what the tools were and what the evidence were that I had. And I think I gave everybody at least a transparent document, agree with me or not, or disagree with me. Now, Mr. Zorn, sorry you were first one up, and I do appreciate all your work. Anything else for me?
I do, just for the record, to address some of the points. As far as Mr. Garrelay and his software is concerned, I just want to note that the notice and comment process, you can't submit software. So I think the purpose of these hearings in part is to receive factual evidence of formal rulemaking that can't be submitted through the notice and comment. And it's not simply limited to expert opinion. This is precisely designed to receive data and evidence that isn't susceptible to being submitted under the APA's normal procedure. And so I would submit to Your Honor that it would be error to exclude that on grounds that it could have been submitted in the notice and comment, or that it's not expert opinion. I think if there's foundation for factual testimony, it should be able to come in these rulemaking proceedings. In fact, that is the very purpose of a formal rulemaking proceeding. And again, Mr. Ascenter, I believe, is a qualified expert. He has a degree in cannabis science. He has, in federal court under Daubert, he would easily qualify as an expert. It's possible that certain opinions might not be under that expertise, and we can take that as they come. But I think that, and I did put in the submission, I think he said he is going to be offering expert testimony. So I do intend to qualify him as an expert.
Sounds fine.
Okay.
I would remember, all I'm telling you all is the things that occur to me as I'm looking at it. This is kind of fair notice for everybody.
Yes, Your Honor. As far as, I think you said the government gets in their exhibits by the homework date. I don't know if
The list of exhibits.
yes, I don't know if Your Honor is going to have supplemental pre-hearing statements.
No.
Okay. So will the parties, all of the parties, not just my side, but the other side, have a chance to respond to the government's?
No, you
Okay.
come to court. You
Okay.
want to cross-examine someone? Come to court.
Okay.
Everyone will have their 20 minutes of fame to cross-examine the people on the other side.
The final point, Your Honor, is, as I've noticed, Your Honor, and all the parties here, there are two judicial proceedings that I'm aware of that bear on the issues here. I'm happy to talk about them, but I also don't want to take up everyone's time if Your Honor's not interested.
Well, one should talk about them when we do the merits, but I don't want to cut you off. Like I said, you put a lot of work into everything, Mr. Zorn. So I guess this isn't the time to argue on it. But if there's something you want to bring to my attention, it was just you're talking about two cases, or?
Yeah, there was a petition for review proceeding that was initiated last Wednesday in the United States Court of Appeals for the DC Circuit.
Got it. I'm aware of it.
And I am not, I'm obviously it's an attorney for my firm, but we may seek a stay in these proceedings in light of the administrator's 25-person list. Nobody really knows how that list was compiled. I could talk about the facts of how the decisions first went out on the day before Thanksgiving, informing parties that they weren't attending as if they didn't already know. But I think one of the, I think for Your Honor, is that it's possible that we seek a stay. I'm supposed to, I think we need to move here first for a stay. We'll do that in the papers if we need to, but
You can, but understand this. If you're moving for a stay for here, just to let everybody knows, if I get a stay that's motivated by Axon, which is a challenge to the structure, I'm generally pretty agreeable because I think everyone has the right to that. But then I think the Supreme Court said, but sort of didn't say in Jharkhasi that was the harm. Being pulled through, an Axon, that was the harm. But remember that you're going to be delaying these proceedings till God only knows when. Now, I've got ways to occupy my time, I'm sure. But understand that when you go back to your seat after you get your stay, marijuana just stops for as long as the district court in the one case the Court of Appeals takes. So I would leave that up to you. I think I don't know what you get later, so you might want to give that some thought. The other thing is regarding Axon. This is not an enforcement proceeding. Remember, everybody's here because they clawed their way in. Fortunately for me, I have a limited amount of things to decide, and one of them is not what the administrator does. The administrator is busy enough. So any challenge to that, you'd think that if it was your clients, I know you said it was someone from your firm, that standing might be a little bit of an issue since you did get to be here. But I will follow the direction of the federal courts, whether it's the Court of Appeals or the district court. I'll follow it to a letter. And anybody that wants to submit a request for a stay, I will give it careful consideration and I will give it a written decision.
Your Honor, and just to preview the issue and why it's kind of like a quasi-Axon challenge in the sense of, I think one of the arguments in that proceeding is going to be that the administrator and the agency actually doesn't even have authority, and that Your Honor does, but that the NPRM itself, the Attorney General order, cabins and prescribes the exact authority that the administrator was to exercise in this case. And it was determine if there's a hearing, notice that hearing, and that in between, there's a step that wasn't actually delegated to the administrator, and understanding that the administrator has a general delegation, but that the specific delegation in the NPRM supersedes that. And the reason that's also important is DOJ is the proponent of the rule in the Attorney General order. And I believe that Your Honor's recommendation should go to the Attorney General and not to the DEA administrator. And I think that's a legal issue that has import that bears on the proceeding, similar to an Axon type challenge. It's not simply a tiny issue. And so I just want to forecast that to Your Honor, because I'm not in the business of surprises.
I appreciate the heads up. And I understand that's what you're giving me. But understand this, that all of the Attorney General's authority was delegated to the DEA administrator by regulation. and it didn't hold any back. So all of the authority that was vested in the statute to the Attorney General, and I know you're not here to argue, you're just giving me a heads up, and I'm grateful for it. But I will tell you this, that I guess what I would remind you of, if I'm directed by the courts to stop, or if a stay is issued, everybody goes home until the court decides that it would consider that. And I know you've practiced in federal court. It would be how motivated the district court judge is, or the Court of Appeals, is to take that case. And again, I don't know how long my lifespan is, but I appreciate the heads up, though. I know that's what you're giving
Yeah,
us. Mr. Fuller.
I'm, obviously, there could be disagreement, but I just wanted to give your honor notice. And then the other case, I initiated an action in my own name, Freedom of Information Act case. I filed for a preliminary injunction on Sunday. As soon as I get a summons, I will serve the agency. And it is Freedom of Information Act related to the ex parte communications that I think everyone in this room can admit existed in some small form. Who knows the scope of that?
Well, wait, before I said in the order that nobody said it didn't, I didn't really make a finding. I just said that no one said it didn't make one. I think I was pretty clear in the order, but that wasn't a finding that anybody talked to anybody. And I don't mean to dance around it, but if you look, I'm not a juggernaut. If the district court or the Court of Appeals tells me to do something, that's what I'm going to do. But ask yourself, is that really what you want to do? It's like, even if you were to assume that every diabolical thought you had ever had about whatever the ex parte communication is, if there is one, let's say that you assumed that it was all true, that people all had notice of what it was. It's doubtful it would interfere with anything. And if people were going to be bad people, would they write it down in a memo so that everyone could read it? I mean, I guess my question would be, do what's best for your client, but what are you chasing? Are you chasing a note that somebody wrote, said, I had an improper conversation with somebody else and I wanted to put it in the memo in case someone wants to indict me? So I guess there's always, as thoughtful as your submissions are, there's always a pragmatic part to what you're doing, Mr. Zorn. And I would just tell you, I'm grateful for the heads up and I'm grateful for the notice you've given me. But I think before you proceed, it's probably worth giving it a thought. Like what's going to end up? And the next time you might not get a handsome guy like me sitting up here. You just don't know.
No, I appreciate your honor's counsel. I think in that is simply, we don't know what the scope of those communications are. And I think it's important to understand. I think that if you look at the rule very carefully, look at the evidence that was submitted very carefully, it suggests that the ex parte communications could go beyond what was disclosed, or maybe not. Who knows? I think that's the purpose of that. That proceeding, I will not be asking that the district court for any relief whatsoever that should impact this. My only point is if those communications do come out in that proceeding, and it is sort of revealed that the government or that they should have filed a memo, as your honor put in the APA for
It's a
expert.
trickier position
Yes.
when that was triggered. And I specifically didn't make a finding on that. I think there's an argument in either way. And I thought that case would be decided without reaching that issue. But it's not that it was a frivolous argument on the part of the proponents of that argument. I didn't treat it as such. They had a position as to where the reporting time started. I thought it was narrow, but I didn't need to reach it. But that doesn't mean that it wasn't a worthwhile issue on their part. So it was.
I don't think any of the papers on either side, and before when I didn't mean, I've attached the submission to disqualify in support of my allegation. So I think that was a good filing too. And I think the government filed a good opposition, but obviously that's a legal dispute. And again, if it comes out that it turns out that the government really should have put in a memorandum or should have complied with the APA in a way that it hasn't submitted to date, that's the only thing that I would just want to give notice to your honor again of your honor has made findings, the government has taken a position. If it comes out that position, it turns out to be wrong, then we will have another can of worms but we can unpack it then.
We can, but you were giving me notice, Mr. Zorn, and I'm grateful. Thank you very much. I appreciate the work you put into these things.
Thank you.
Thanks. Okay, hemp for victory. All right. Hemp for victory. Mr. Klein and Mr. Callan, who's lead counsel? I just need one of you.
That's a very good question, Judge. I guess I drew the short straw since I was here first.
Okay, if you could give me the appearances for both of you then, please.
Okay, Abdul Kalan and Andrew Klein for Hemp for Victory. Good morning, Your Honor.
Good morning.
We've heard you loud and clear. We will be available the week of the 13th, although our proposed witness is not available until after the 17th. So as long as someone else will step up to the plate that week, assuming the DEA's witness is not available, we can make that week work, Your Honor.
The week of the, tell me again. It always scares me when someone's heard me loud and clear that I might not remember what I said.
I think you said you were looking for mid-January, January the 13th
I was
week.
looking to start then, if within reason. I'm not looking to hurt anybody. but
We
yeah.
can make that work. Our witness is not available until after the 17th, I believe.
Okay. Your witness is not available until after the 17th. We can certainly work around that. Let me just take a note. All right. By the way, what I'll be doing is I'll be giving pre-hearing ruling afterwards, setting the approximate dates for everybody. My default setting is that everybody gets to put on their case. We've gone to an awful lot of trouble for people to be denied on their case based on a small matter. And I'm just looking to see here. Your position is you're not particularly looking for district court intervention now, but you reserve your rights to do so.
That's correct, Your Honor.
Okay. I don't want to disappoint you since Mr. Zorn and I are up here for so long, but I think that's all I have for you. I thank you for the care you put into your papers.
Thank you, Judge.
Okay, the Commonwealth Project, I believe, is next. And represented by Ms. Fair. Hello, Ms. Fair.
Good morning, Your Honor.
Good morning. Appearance, please.
Kelly Fair on behalf of the Commonwealth Project.
Address? Business address
Business address
for the appearance?
is 1 Market Street, San Francisco, California,
Zip.
94119.
Great, thank you. I've looked at your availability. Okay, one of the things in your papers, it says that your witnesses are available after 2 p.m. As I think the line came from Mean Girls, that's not a thing. I'm going to be doing enough here to get everybody on. I can't deal with who's after 2 o'clock, and I can't start at 2 o'clock because I've got security for a certain amount of time. So I'll work with the schedule. I was dying of curiosity, Ms. Fair.
Yes.
What's the deal with 2 o'clock? Is the person like babysitting or a part-time job in the morning? What's going on?
No, Mr. Kent is not babysitting, but it was a combination of professional and personal matters that just kind of rolled into we need to knock out mornings. And so we're hopeful that we could have our witness start in the afternoon. And I understand you have a lot to juggle. We will work with what we're given.
But I'll work with you.
And I will do the best I can to be
There might be
flexible.
a day, like if I assign a day and for some reason it's just critical that he can't be there that day, we'll move the day around.
Okay.
Why don't we do that? But what that would mean is that I'd either have to put witnesses in the middle, and as everyone is probably assessed by now, I don't have the IQ for that. I need to do a witness, do the opening, closing, and be done with the witness. But if something comes up that's just undoable after I give you the pre-hearing ruling, then let me know.
I'll let you know. That's fair. And just to be clear, on January 13th through the 16th, I am not available.
Got that.
And so just want to make sure that.
Got
we don't
that.
have to go
My
that day.
unavailability for you shows me January 13th through the 16th and February 3rd through the 7th.
Yes, sir.
I'll work around it. No problem.
Great.
Anything else for me?
Just a little point of clarification around written affidavits. Given the limitation on witnesses, we had 2 expert witnesses that would be quite probative to the issues that you're considering, but we didn't want to seek leave to ask for 2 and instead put our medical expert in a written affidavit. Is there any clarification you can give around, I understand we have to use the Jeff systems to submit, but I was looking at the rules and it seemed to be that potentially they needed to be exchanged today at the pre-hearing conference?
No.
No, it'll be sometime
No.
before the homework date.
I appreciate the thought that you put into that. Here's what I don't want in everyone. I don't want someone to say, oh yeah, we'll call one witness and then give you like 37 affidavits and go read them. Seems to me you've got 2 expert witnesses that you think would be helpful. The regulations, I think it's 13, 16, maybe 59, say that affidavits are admissible, but they are entitled to diminished weight.
Correct.
2 doesn't seem awfully much. Why don't you submit them? Did you notice them as exhibits?
I did.
Then submit them and then we'll deal with them at the time. If they're unduly cumulative, then I'm probably gonna put them out if they're not material or relevant. But put them in like any other evidence. We'll look it over at the time. Okay.
Okay, and it's just one affidavit. We'll take Robert Kent live and then Dr. Bone. She's currently in a written affidavit. And I wanted to make sure that the court had the right people giving foundation to for the studies, et cetera. And we will take note to make sure that we focus in on what is probative and what you need to read and no dump truck here.
I
Right.
couldn't ask for more than that. That sounds fair, Miss Fair. And I think that is all I have for you. Anything for me?
No, that's it, Your Honor.
All right, thank you.
Thank you.
And I'm looking for Dr. Kirschenbaum. Thanks. All right, representative for Dr. Kirschenbaum. Good morning.
Your Honor, Rafe Peterson for Dr. Kirschenbaum.
Good morning, Mr. Peterson. And let me see what I have for you.
My office address is 800 17th Street, Northwest, Washington, D.C.
Okay. I'm just looking through my notes. Thank you for your thoughtful papers.
I don't think availability is going to be an issue for us because we were the 8th through the 12th, and it sounds like we're starting a little bit after that.
Second. Your availability. By the way, if anyone needs to call their witness by VTC, just let me know by the homework date. I can accommodate that. I'm just looking for your availability that you put on
Page
page
17,
17.
I think.
Oh,
Your
I've
Honor.
got it. I've got a note. All right. You've given me a good amount of availability. What do you think the issue is?
I said there's no issue. I'm sorry, Your Honor. I said ours was 8th through the 12th. He wasn't available, and I think those dates aren't on the table. So
Oh, but you've certainly given me enough dates that I can work around.
great.
That sounds fine. I think that is all I have for you. You calling him in person? I'm just wondering, is he going to be by VTC?
Yes, he's going to come in person.
Okay, sounds fine. That's all I have. Anything for me?
No,
right.
thank you, Your Honor.
Thank you. Village Farms? Counsel for Village Farms, please.
Good morning, Your Honor. Shane Pennington and Tristan Kavanaugh for Village Farms International and Corp.
Okay, firm address?
Porter Wright, Morris, and Arthur. Let's see, I'd have to look at my card to figure out what
Could it be 9132 Strata Place, Suite 301
that sounds like it.
in Naples, Florida, 34108? I just got lucky. I just looked down and there it was.
I'm glad you had it there, Your Honor.
Yeah, me too. Let's see. You have like no availability hardly. It's not available for a lot of January.
I had a family trip planned with flights booked before any of this kicked off.
So my sense is that you're not willing to invite any of us to accompany you on this
You're
family trip.
you're all welcome.
I think you were very brave to come in here with everybody working so hard and the date set in the Federal Register to come in and say you're going on vacation. All
Well,
right.
Your Honor, if whatever dates you set, will be here.
All right, I will try and work it out. It looks to me like you're not available the 8th through the 15th, the 24th through the 26th. Well, in as much as the 26th looks like a Sunday to me, I think that's okay. Yeah, you've given me enough that I can work with. I will try and work something out in there, and I hope you have a nice trip. And I think that might be all I have for you. Let me just check one note. Do you have a sense of exactly what the area that you're going to be offering Dr. Harlow in as an expert witness?
I wouldn't want to limit myself to it right now without, being able to write it up for you or present it at the merits hearing. But in general, we intend to present him on the abuse potential factor and on currently accepted medical use.
All right. Anyone bring an expert? That's fine. Anybody bring an expert? Remember, before you get going in your short opening, let me know what you're offering the person is an expert in, if it's not in your papers. And I think that's all I have for you. Mr. Payton, anything for me?
I did have one question, Your Honor. I totally respect the conclusion with respect to the government being the proponent of the rule, and wanted to make sure that I understood that your point there is that, look, they could change positions, they could make up their mind, they could, they're going to be a cheerleader for one side or the other. And I respect that. I guess my concern is that if I understand your orders, the right of particular parties to cross-examine witnesses hinges on what side the witness is on, if it's a cheerleader for this side or that side. And so I just wanted to get clarification that to the extent that the government and their witnesses want to put on evidence that's contrary to, our view of the world, that we would have access to cross-examination.
You won't, because there's no other way to do this. Anybody who is on the pro side gets to examine the anti side, and the anti side for the pro side.
Okay.
It's like anything else. I don't know what the government's case is going to be, but I can't have the proponents and the anti-proponents on each side like trying to do a better job or outdo each other. I understand your motivation, and you filed a very thoughtful paper, and I'm grateful. But the way that it must be is that you can cross-examine the person with the opposite position than you.
And if the government takes that position, we can cross-examine them? Or
No.
Oh,
You
okay.
can't, because think of the way the record would look if everyone on each side didn't like the job that each of you did. Now, I know that you're all divided here on the bride side and the groom side, but let's say that somebody on the groom side says, well, I can get more out of this witness than that. The record would be a mess. The person who sponsored the witness might say, well, that's not why I brought him here. I object to my own witness. There's no way to make it work. My advice to you is you understand all the issues. I even know that in reading your stuff. But do the best job you can with what you have. And
Okay.
anything beyond that is going to be argument.
Right. Okay.
that
I
you're
have
gonna
no
bring-
desire to argue with you.
No.
Your Honor.
I meant argument at the conclusion of the witness.
I understand. Okay. Gotcha.
No. I didn't anticipate that you and I were going to argue with each other.
No.
But that's going to be as good as it gets. And look, you made your concerns very eloquently. I understand them. I'm not seeing any basis for them yet. And if I were to follow something like a tabloid magazine to say who thinks what, you all wouldn't get a fair hearing.
Right.
It has to be restricted to what's here. Now, if you have an argument to make, everyone will have a chance for that brief after you present your witness. Bring it to my attention. I wish I had a better answer for you, Mr. Pennington.
Okay. Thank you very much for that. Thank you for addressing it. I did have one other thing.
Sure.
I understood you to say, look, motions practice is complete, and I want to respect what you say. And I wanted to highlight that there are some things that you haven't yet addressed, whether intentionally or not. And I just wanted to get clarification about whether you want to address them. I know in Hemp for Victory's pre-hearing notice, they raised the prospect of needing discovery to make sure that the proceedings are transparent with respect to the scope of the ex parte communications. I heard your colloquy with Mr. Zorn on that. I just want to make sure you're denying any request for discovery, any request for a deposition, anything like that. You don't want to hear it? Or could
Well,
we put that in
let's-
on paper for you?
Let's talk about it for a moment.
Okay.
There's been a significant amount of case law on this.
Mhm.
And the agency's seminal case on it is a case called Sidecheck. And while we're talking, if I can come up with the site, I will. And if I can't, I'll just put it in the pre-hearing ruling.
Okay.
The agency's point of view is that the administrative law judge has no authority to issue orders for discovery. Now, there is some authority for the issuance of a subpoena. I can issue subpoenas, they're enforceable in the district court. But before anyone goes and gets their pens and starts writing, because they said that nice old man said he'll give me a subpoena, what I would direct your attention to is 21 CFR 13-16-52 sub D, which says that I can sign and issue subpoenas to compel the attendance of witness in the production of documents and materials. And here's the kicker: to the extent necessary to conduct administrative hearings pending before me. So it is a very narrow sense of it. And the case law has not been particularly favorable. Another case that I will put into the pre-hearing ruling for you is a case called Miami Lucan. And what happened with Miami Lucan is that the agency protested about a subpoena.
Mhm.
The judge, a very nice, wise old man, said, well, I think this is fair and it's narrow. And in the Sidecheck case that I just referenced you, the agency made it very clear that you have all these other tools, including subpoenas. And the APA said that the ability to issue subpoenas is one of the enumerated authorities to the ALJ. And in this wise old judge's view, if it went on to just be judged on appeal, then what you'd be doing is testing it for prejudice, and there would be no way that anybody could test it for prejudice, which really gave the government a complete veto
Right.
over any exhibit, or anything you'd like to subpoena. So then the Sixth Circuit got it. And what the Sixth Circuit said is, well, it's all really interlocutory. I'll include the citations for everything in the pre-hearing ruling. But you see, even if you did get the relief, if one side of the litigation equation has the opportunity to veto it, not that I'm questioning the Sixth Circuit at all, then you'd have to wonder if it's illusory relief. So when you say I don't want to hear it, and I know you meant it in a good way, but I don't have authority to issue orders for discovery. So I think that you will find it an unsatisfying enterprise. Does that make sense? And that it's not that I don't want to hear anything. I'll read and answer anything I get. I think that everyone's had a lot of chance for motions, and what I did is I tried to answer them as quickly as I could, and I put on my thinking cap for all of them. If somebody is dying for something, I know I'm shooting myself in the foot here, but I'm unlikely to just reject it out of hand. So that's a long answer to a short question, Mr. Pennington. Did that do the trick?
I really appreciate your answer. I hesitate to flood you when I know that you are doing, you're working frankly at an impressive clip, even
you.
by busy lawyer standards. And so I don't want to put things in front of you that you don't want to see. I guess I heard you loud and clear about, the subpoena power. I guess that I read 5 USC 556C and the authority that you have to take and have taken depositions, and then 13-16-52H, which incorporates the express powers from 556 and then gives you those to you as well.
Yes. And if you, by the way, I didn't mean to interrupt you, but it's even worse because if you read the AG manual,
I have, yes.
Great. But relative to that section, it says that these are enumerated authorities that can't be curtailed by
That's
the
what
agency. And yet,
That's why I'm a little bit confused.
you're probably not confused.
Okay. Well, okay, one last thing, and then I'll sit down. I just wanted,
Or, hey, you're not
I
wasting
want you
your
to
time.
understand my project here, right? It's your project. It's to have a transparent hearing and a complete record.
Yeah.
And whatever, we don't know what the outcome's going to be. We don't even know what the evidence is going to be. We don't even know who's making what case at this point. So I'm trying to grapple with that and make sure that this is a formal rulemaking process. We're supposed to have, a record at the end of it that somebody can do something with, even if it's on review and it's deferential standards. I mean, like you said, we got to work with what we
Well,
can.
Loper Bright is milling around out there too.
Do you have
So-
an antidote for the substantial evidence standard, which is also fairly deferential if we don't get this done right this time?
Well, I will tell you this, that Loper Bright that I just mentioned has to do with what deference they give the standards the agencies have put on. And no one really knows what that means in this context. In general, the agency drives within its lane.
Of course.
I would just, that's not true with every agency. This agency generally will drive within its lane, and it'll give, even if the courts eventually don't like something that they did, they won't just announce it. They'll generally, in their final orders, they'll explain why they did something so that you can get less of a Chevron analysis to it that would be required some places. Is it rational? And something less than that. I would say the substantial evidence standard, it doesn't affect me because, as you know, mine is a preponderance of the evidence at the
Right.
hearing, oddly enough. And then the standard for review at the Court of Appeals from the final order is substantial evidence. But it has to be based on the record, and it's quite clear as to what those things are. The other part of it is that the kind of discovery you're talking about in the fulsome record, that has much more to do with a contested enforcement case.
Right.
I think there is a case that I will also put into the pre-hearing ruling. It's called McClellan v. Andrus, a DC Circuit case that says a denial of a discovery request is actionable to the extent that it causes a due process violation.
Right.
Now, here's the tricky part about that. The Court of Appeals said that, and the agency even acknowledged that in a case, but it gives me no more authority to order it. So to the extent the agency doesn't give you the discovery that would keep it above the level of due process, it does so at its own risk.
Right.
Now, I didn't write all this stuff. Somebody else did. But that is what McClellan v. Andrews says, and it's still good law. No one can touch it.
Right.
So you might want to start with asking the agency for it, whatever it wants.
Right.
Again, there's a certain amount of self-loathing in me telling you this, but I'm unlikely to throw anything you give me into the waste paper bin. I mean, I'll read it, but everybody's had a pretty fulsome opportunity to file motions. So there's the best answer I can give you.
Really
Uh,
appreciate it. We're trying to do the same. We're working, just so that it's clear, Village Farms is operating in the sort of same decision tree analysis that Mr. Zorn is, and hear you about, like, look, go to the Court of Appeals, get a stay, then we all have to wait around. We won't have this handsome chief administrative law judge.
Exactly my point, and
I-
I'm hoping my wife is watching this thing on
And-
TV.
And so that calculus, I think, from our perspective, comes down to, okay, well, can we build a record that will allow us to have meaningful judicial review at the end, or can we not? And what tools
You
do
left
you?
out an option. The other option is, although the subpoena power is tested for prejudice, McClellan v. Andrus is not. Your third option, obviously, I'm not going to practice law for anybody, but I would say there's a third option, right? If you didn't get enough and you find some way to sort it out, that it reaches a due process violation, which in a case that's not an enforcement action, I think you've got a tough row to hoe.
Agree.
I think that, but that is your third option. I didn't mean to interrupt you, but I didn't want you to think you only had two options.
No, I appreciate that. And yeah, we're just trying to figure out that calculus, and I guess that we'll decide what we want to put in front of the agency, but we understand your position is that you just don't have, I mean, we could put it in front of you, but view of the law based on the precedent and what will be in the order after this is, look, I don't have authority to give you discovery. If you want to take that to the agency, go ahead.
Yes, but
Okay.
as I said, I'm unlikely to just not answer something. As a matter of fact, I have a handsome little block that I use of all the reasons that the agency has told me I don't have discovery authority. They feel quite emphatic about the issue. can
I
assure
believe you. Thank you, Your Honor.
Mr. Pennington, thank you for all the work you put into this. I appreciate it. All right. National Cannabis. All right, National Cannabis Industry Association, please.
Morning, Your Honor.
Welcome. Appearance, please.
Nicholas Camiotti, Fox Rothschild, on behalf of the National Cannabis Industry Association of co-counsel Khurshid Koja behind me from Greenbridge Corporate Counsel.
And
My address is 49 Market Street, Morristown, New Jersey. And I have Mr. Koja's address right here.
thank you.
500 Capitol Mall, Suite 2350, Sacramento, California.
Thank you. And welcome. And
And we're, we are, just to be clear, in favor of the proposed rule, but subject to our limited objection, which we put in our notice.
you did cleverly put too. It was, if I may say, a fine bit of lawyering.
We wanted to, thank you.
It was.
Mr. Koja was the driving force behind that.
But would you have admitted that if he-
I'm just here for jokes.
Would you have admitted if he wasn't here?
What was that? I'm sorry.
Would you have admitted that if he wasn't here staring at you?
You
I saw
know,
him fold his arms.
I probably would have taken credit, yeah. But thank you. But that.
Well done. No one goes to law school to be a nicer person. All right. Now, couple of things. One is that I note that you helpfully provided some cases and some statutes. You can cite anything you want. Just so that everyone knows, you don't need to give me cases or statutes. Even at my advanced age, I can find them, but that doesn't mean I'm not grateful for them.
Understood.
But anything you cite, I'm happy to read. They're not going to be admitted as evidence, but you can certainly rely on them. And I'm grateful that I don't have to look them up. So thank you for that. Affidavit of Jennifer Mitchell.
Yes.
Okay. Tell me why under 131659 it wouldn't be unduly cumulative. Tell me about that.
Well, our.
You're not on the spot. I'm not going to suppress it.
Yeah.
I didn't mean to interrupt you, but that's what my concern was.
Right. I mean, obviously, we have the limited objection. That's what Mr. Johnson would be addressing. But as a proponent of the rule, we still wanted to make sure that there would be an opportunity to be heard so that we can talk about the acceptable medical use and how the potential for abuse is less than some of the Schedule 1 and Schedule 2 drugs. So we wanted to make sure that, we were being afforded the opportunity to, because we are, have our limited objection, but we still are in favor that, I guess we wanted two bites of the apple there and have a second person to make it clear that we are a proponent and that we fully support all of the arguments for the rescheduling. But we also are in favor of what we think is a little bit of an end around on looping in some other cannabinoids into Schedule 1.
That sounds fair enough. So your position is that you'd like to support that position, and the way to do the least amount of harm is to do it through an affidavit, since the greatest harm is the definitional change.
Correct.
All right. Again, I have to compliment you. Very lawyer-like argument. Look, the briefs were all good. I'm very grateful to everybody for the work they put in. But it was good to read something that was that thoughtful. So thank you.
Well, thank you, Your Honor. And just to be clear, we want to move expeditiously. Our members are looking forward to having cannabis hopefully rescheduled to Schedule 3, and we do not want to have any unnecessary delays, and we want to proceed in an expeditious fashion. We will make ourselves available for, other than the dates that we put in our notice that our witness was not available. We will make ourselves available at your honor's requests, and we will be here looking forward to moving the process
right.
as quickly as possible.
The unavailability that I have for you is January 30th through 2/7 and 2/14 through 2/17.
That's correct.
All right, I think I can work around that.
Okay.
I think not a problem. Let me just take one look. If I have anything else for you. Anything else can wait till you
Okay.
show up for the hearing. Anything else for me?
Nothing else, Your Honor.
All right, thank you.
Thank you very much.
All right then. Veterans Initiative 22. Counsel for Veterans Initiative 22.
Yes, good morning, Judge. My name is Cheryl Murray Powell Esquire. I'm with Dumar Allsworth et al., based in Fort Lauderdale, Florida, 1177 Southeast 3rd Avenue, Fort Lauderdale, Florida.
Thank you.
Okay.
morning.
Good morning, good morning. I'm joined by Sean Hauser as well as Timothy Swain from Vicente LLP. Them and their team, they were the primary drafters of our submission.
So I should blame them if there's a problem?
No, it was a team effort. It was a team effort, and along with our witness, who is the executive director of Veterans Initiative 22, and she's also has her master's degree from the University of Maryland School of Pharmacy.
Right. And who are your two co-counsel? I know you identified them. If you could raise your hand.
Yeah, so Timothy Swain
All right. Mr.
and
Swain,
also Sean Hauser.
sitting on the wrong side of the aisle. And, all right. Couple of questions.
Sure.
Not many. The thing that I was concerned about,
Sure.
this whole massive affidavit thing, it seems to me proposed exhibits 22 through 30
Yes.
seem like a massive affidavits, which is not really what I'm doing. If there's one or two affidavits,
Yeah,
I'm
absolutely.
happy to suck it up. But if you could look at them, why don't we limit it to a smaller amount within your discretion, if you could?
That's completely reasonable. The rationale behind the affidavits is really to make sure that we are representing the varied interests of the veteran constituent community that we support. When you look at the veteran population, it's a very unique, very much harmed population due to their service, but also extenuating circumstances upon their return. So these affidavits, in part, were to demonstrate not only the harm that was done based on the diversity of veterans that we support. Some have disparate harm based on ethnicity, Black and brown veterans who had additional harm because of their ethnicity. Some were faith-based users of cannabis prior to their service, such as our Hindu and Rastafari veterans that serve. So not only were their religious freedoms violated, but also their United Nations cultural protections. And also, there's a lot of veterans who suffered dishonorable discharge just because of their cannabis use. So we wanted to provide some color to those distinctions that make our veteran community very unique with regards to the harm, which drives the indication, which drives the medical necessity, acceptable medical use, and medical benefit.
What I would urge you to do, there's just tons commendable about what you do, even to the title of the reason that your organization exists.
Thank you,
Would-
Judge.
I mean it. Even the number 22 is just remarkable to think about it. But what I would urge you to do is, when you're looking at the affidavits, and I'll count on you to pare them down, look at it as to something that will help me one way or another to move the needle on the issues that I've got. I've got a fairly narrow issue. Two things, as I've told everybody before, I don't have an opinion about marijuana. Tons of people think it's good and tons of people think that it's bad. Everybody has to get used to the idea that however strongly held your beliefs are, and I get used to this every day. I have someone reviewing what I do. You could be wrong. Like anybody, any of us could be wrong. That's not an indictment on the person's point of view as to whether marijuana is good or bad. But it won't enter into this determination. I just have to decide a fairly narrow amount of things. So when you're looking at your affidavits, since I've already told you I'm sympathetic to your mission, it's not about determining whether it's good or bad. It's whether something's going to move my needle one way or another. Does that make sense?
That makes perfect sense. That's fair and reasonable. I think the causation ties that we were trying to demonstrate with our filing, it seems like you've recognized those, and we can really narrow our focus to the medical acceptable medical uses, as well as our the addiction related misrepresentation as far as the scheduling of Schedule 1 currently.
I couldn't ask for more than that. Thanks. Let me just take a look. See if
Okay.
anything else. You know that you already mentioned this though, that under 131659 of the regulations, their affidavits are entitled to diminished weight, but it's not really a contested issue. Like it's not like facts going against each other. And let me take one look. I think that's all I have for you. Do you have anything for me?
Yeah, based on the need to reduce the number of affidavits, is there opportunity at this point for an expert witness, or would that be not consistent with your instructions?
Well, I wouldn't like any surprises. I don't even like them on my birthday. What I would say is you've given affidavits. Well, look, an expert can always help, but I would say that what I would ask you to do is to take a look at the affidavits you have available. Pare them down for me, and I will carefully consider them, just based on the pool that you currently have, because there are people that are going to go after you at that podium. And if I were to say, yeah, give me more of them, that's what I'm going to get. So here's what I would ask you to do. You've noticed evidence. The government's going to notice all of those by the homework, theirs by the homework date. Take a look and see which ones move the needle. Re-edit them if you want. I mean, do
Okay.
whatever you can do, but keep them at a reasonable number so I can read it and depend on it to go your way. If that's what I'm looking to do, if that's where the evidence is. No matter what, no matter which way I go, let me tell both sides, I'll deal with all the evidence. I mean, if it's contrary to the way I'm finding or for the way I'm finding, I mean, all of you get to have your say and to have your evidence considered. But that's the advice that I would give you. Does that make sense?
That makes perfect sense. You have our commitment to narrow down our affidavits to items that are most relevant. Thank you
Thanks.
so much, Judge.
Re-edit them if you need to. I don't have them yet. All right?
Okay, sounds great. Thank
Sure.
you so
Thank
much,
you.
Judge.
All right. Cannabis Bioscience International Holdings, please. Hello, Mr. Picasso.
Hello, Your Honor. Thank you.
Would you please give me your name and your business address? I know you're not an attorney. You're here representing your Cannabis Bioscience International Holdings.
Yes, Your Honor. First of all, thank you for allowing me this opportunity. My name is Dante Picasso. I'm the director of Cannabis Bioscience International Holdings. I'm not an attorney, so I'm a little nervous. I apologize.
Don't apologize for not being an attorney. Believe me, there's no one in this room that at some point in her life didn't wish they weren't an attorney. Just imagine if you could never win an argument at home. That's what it's like. So thanks. Did you give me your business address?
1625 Main Street, Houston, Texas.
All right, thank you. Look, you didn't give me a pre-hearing statement. And I asked everybody for a pre-hearing statement. And to the extent that you meant to, like, or if the dog ate your homework or something, I have a response to the preliminary order, but I had asked everybody for a pre-hearing statement.
I thought I sent it. Maybe perhaps the format was not correct.
I don't know, but I don't have a pre-hearing statement for you. Which, not to make you overly uncomfortable, I do want to make you a little uncomfortable. I needed a pre-hearing statement so that I could talk to you about your availabilities and,
Oh,
see,
I'm
most times
available
if,
at any time.
right, but the time had already passed. See, I needed that pre-hearing statement. Um, Look, there are things that I wish I had done, like buy Google stock, but I didn't. Let's do this. You're not represented by counsel, but so I'm going to ask you some questions, but you're going to have to get me a pre-hearing statement by the homework date.
Absolutely,
All
absolutely.
right, and it's going to have to comply with the instructions that I gave everybody, in the order for pre-hearing statements. Okay.
Thank you, Your Honor.
Sure. If you were a lawyer, A, you'd be a lot more embarrassed, but B, it wouldn't go as well for you, I think. So let me ask you this. What is your availability? Are there any dates you're not available in January and February?
I will make myself available for any time that you decide that I need to be here, sir.
All right. Um, See, I don't, let me ask you this. Are you calling yourself as a witness?
That's what I thought I was gonna be, sir. Yes.
It can still be. So you don't have anyone to represent you. So what you're going to do is you're going to take the stand, and I'll ask you some questions, presumably, and you'll tell me anything you want to tell me about this, right?
Yes, sir. Yes, sir.
Okay. What I really needed from you was a description of what you were going to say.
I did send it, Your Honor.
It was
Maybe
one.
again, maybe the format was not legal, like, the
Well,
attorneys
you
have
sent
said.
me not to belabor it. Nobody likes a person that does that, but you did send me general notice of appearance early on, but I needed a pre-hearing statement to tell me what evidence you wanted to put in, what you were going to say. So do me a
Your
favor.
Honor, I sent a 78-page document.
All right. I don't have a 78-page
Oh, my
document, or I
God.
wouldn't be torturing you. But let's do this. There will be no harm about it.
I-
If something happened to it, find it and send it to me again, and then I'll review it. Does that seem fair enough?
Absolutely. I apologize, but I did send it in. And again, I apologize. Maybe I made a mistake. Maybe I didn't use the proper format, but I did. It took me about 2-3
Well,
weeks to put it together.
I would
And
say this. By me not torturing you, I'm saving myself from the horror that I'll feel when it's sitting on my desk when I go back in. So I don't have it. It didn't come in. I've got pretty good systems for getting what comes in on email or what comes in delivered. I've been doing this a minute or two, and I'm
I
pretty
actually
happy with my
printed
system.
it. I have it with me.
That would be torturous. So why don't you do this? If you have an extra copy, what you can do is you can bring it to the hearing clerk window, which is right outside, and you can submit it there. Because if you were to give it to me now, then everyone would know that I was not capable of reading a 70-page document while I sat here. So when we're done, there's a hearing clerk window outside. You could submit it there. Is that okay?
Absolutely, Your Honor. Again, 1,000 apologies. I don't know what happened.
Well, actually, that'll, if you can submit it there, we'll take a look at it. I'll give it a good read over. All right?
Thank you, Your Honor.
You're welcome. Anything you want to ask me about, Mr. Picasso?
No, actually, I just want to say thank you. It is an immense pleasure experience for me to be here. Miss Queen Fox was just absolutely incredible in answering all my dumb questions, and somehow I'm here. I want to thank the Drug Enforcement Agency for considering our situation, the attorneys that are against the reclassifications and the ones that are pro-classification. This is an historical event, a beautiful situation, and thanks for everybody's collaboration.
Well, thank you very much. And
Thank-
Miss Fox is quite brilliant.
Thank
So
you.
thank you. She's truly the brains of the operation. All right, then. We've done all the pros. We're going to hit the anti side. The state of Nebraska and smart approaches to marijuana.
Good morning, Your Honor. Patrick Philbin from Torridon Law, PLLC. I also have with me Chase Harrington from Torridon Law for Smart Approaches to Marijuana. Our business address is 801 17th Street, Northwest, Washington, D.C.
Thank you. As I've said before, that was a very thoughtful piece of paper you put in.
Thank you, Your
I
Honor.
did the best I could with it, but sometimes that doesn't feel good on that side of it. But it was a very thoughtful piece of paper, and I was very grateful for it. A lot of thought went into it. A lot of good legal analysis went into it, and thank you.
Thank you, Your Honor.
Sure. Now, getting back, I think I may have everything I need on both Nebraska and Sam. Let me just take a quick look. Oh, you would ask for 150 minutes. One witness, I think 120 minutes probably be enough to get.
That's fine, Your Honor.
If I'm look, whoever it is going to be able to finish their sentence. But I think 2 hours is probably going to be fine. And do you have a sense of, and you can wait till you get there, the sense of what's the specific area you're going to offer Dr. Madras as an expert in?
Well, it would be to address potential for abuse, addiction, and also currently accepted medical use. I think will be the major focuses.
That sounds reasonable. Thank you. And all right. I think free papers. That's everything I have. Anything you have for me?
No, Your Honor. Thank you. But there is just a separate appearance for the state of Nebraska.
Oh, that's fine. I thought you were consolidated.
We are consolidating to just cut it down to the one witness
Yeah.
for both of us, but the state is separately represented just so that they put their appearance on the record.
Sure, please.
Thank you.
Thank you very much. Welcome.
Good morning, Your Honor. Zachary Villaianco for the state of Nebraska. Sam has adequately represented our position, and we do intend to present jointly with Dr. Madras. I just wanted to stand up and say that I am here. I make my attendance known, and that's all that's going on here.
Thanks. Do you have any sense of who's going to handle a witness?
I think that's still being worked out. I
fine.
expect Sam will take the lead, but there's still discussions about
I
that.
don't need to know until you all stand up. I was just wondering. Do you have, and I know that you're a Deputy Solicitor General. Do you have an office address?
Sure.
Thanks.
2115 State Capitol, Lincoln, Nebraska, and that's 68509.
Thanks. Anything for me?
No, Your Honor.
Well, thank you very much.
Thank you.
Okay. All right, Community Anti-Drug Coalitions of America. Mr. Evans? Mr. Evans, you're going to be a busy guy.
That's my privilege, Your Honor.
Well, thanks.
And I'm going to enjoy appearing before you. You are a very thoughtful legal scholar, and I've learned a lot from you so far.
Look, I'm never going to stop you from all that.
No, I know. I understand.
And as a matter of
And I
fact,
think
if
you're
anyone else
good-looking.
thinks of anything positive during the entire proceedings that they'd
Right.
like to say,
Right.
that's a sure way not to get interrupted. Thank you for saying that, Mr.
Okay.
Evans. And I know that you are representing quite a bunch of them. Let's have your appearance. And if you could tell me, it's my understanding that you are representing the CADCA, first off, the Community Anti-Drug Coalitions of America, the Cannabis Industry Victims Educating Litigators, which is civil, the National Drug and Alcohol Screening Association, NDASA, also Dr. Finn and Dr. Drum. Is that correct?
That's correct, Your Honor.
So since I have you at the podium, if you could give me your appearance and office address, we'll go through and we'll ask, we'll deal with all of them.
Okay, my name is David G. Evans, and I am Senior Counsel of the Cannabis Industry Victims Educating Litigators. Our office is at 203 Main Street, Suite 149 in Flemington, New Jersey, 08822.
Thank you.
And I'm representing the Community Anti-Drug Coalitions of America. So in the future, if I can just refer to them as CADCA,
That's fine.
rather than having to lay that whole thing out. And Civil would be my organization. And then I'll just say Dr. Finn and Dr. Drum. And then the National Drug and Alcohol Screening Association, I'll call NDASA, just for make it, I don't have to stand up and recite everybody's name. Okay.
Sorry. I was just getting my equipment. All right. Let's see. Oh, one thing. This was one issue that we've had. Everybody gets column A or column B. If a person's represented, then everything has to come through their counsel. So I get no surprises from clients. If we could talk to everybody about that, I would be grateful. It helps them, it helps you, it helps me. So if you could talk to, I think there's at least one of your clients that had a different point of view.
I think you're probably talking about Mr. Drum. I received a complaint from your office about him. and-
Complaint is strong.
Well,
I would say that's strong.
whenever I get any call from a court about a problem, I consider it a complaint that I have to deal with. I apologize for what happened.
No need.
He experienced a personal tragedy in his family. His sister was killed by somebody who was intoxicated with marijuana,
Sorry.
and he has a very strong emotional involvement in this. And he has now been straightened out, and that will never happen again.
Well, a lot of what happens is built on
Yeah.
enthusiasm. No need to apologize whatsoever.
Right, okay. So do you have any other issues, Your
I do.
Honor?
If one thing that confused me at first is that you've got a, I guess it's a little cover sheet that you use. That I understand its purpose when you're dealing with clients, but it mostly says, don't consider any of this legal advice, and I don't recommend anybody.